So what are we going to be looking at in this seminar? Well, we're going to be covering the following aspects of the permanent impact of CIGA, as opposed to the many temporary measures imposed by the Act during the pandemic, which you will all probably have been aware of over the last couple of years. So the three things I'm going to look at in particular from CIGA are the Part A1 moratorium and restructuring plan. Secondly, the Act's restrictions on termination for insolvency. And finally, the impact of these debtor-friendly changes on the supply chain. We're then going to come on to discuss the separate, but as I say, highly topical issue of enforcing adjudication decisions, which involve insolvent parties, because of course there are going to be more of those scenarios. And we're going to look at that by outlining the context of the case law on the issue, and then discussing the impact of two important recent decisions, Bresco and the John Doyle case. And the first case is, as I say, Bresco Electrical Services and Michael J. Lonsdale, which was handed down by the Supreme Court in 2020, and John Doyle Construction and Erith Contractors, which Lord Justice Coulson, on behalf of the Court of Appeal, handed down in late 2021 last year. Coming on to our final slide, where does that leave us now? We should bear in mind that Lord Justice Coulson's remarks in John Doyle were obiter, but nonetheless, the result of those comments is that the ability for an insolvent party to enforce an adjudication decision may be largely constrained. I say enforce, not commence an adjudication, because that is now settled by Bresco. Bresco remains authority that an insolvent party has the right to commence an adjudication, but we may be now in territory where enforcing that adjudication decision is going to be much trickier. There will still be some instances where enforcing the decision is possible, as noted in John Doyle, which includes occasions where the adjudicator's decision by agreement determines the final position between the parties. And in such cases, the adjudicator could examine all the parties' claims and cross-claims and thus carry out, in practical terms, the insolvency exercise. Enforcement may also be possible where there is no dispute about the cross-claim and where the disputed cross-claim may be found to be of no substance. But even so, enforcement and avoiding a stay of execution remains dependent on the insolvent party providing security for the adjudication sum. And as noted in John Doyle, such security needs to be clear, evidenced and unequivocal. And these can include a third-party guarantee or bond or undertakings from the liquidator, such as ring-fencing the sum or providing ATE insurance. And it should be noted that security is required for both the adjudication and any consequent cost orders.